Okay, let's do a super quick overview of patent law. Reminder that patent law is the law that applies to inventions. This is generally anything sort of scientific or pharmaceutical or in manufacturing. It requires registration to get protection. Registration happens with IP Australia. And registration will give a person, the patent owner, and who is the inventor, in general, 20 years of protection. And we'll talk in a moment about what that protection gives the patent owner. But firstly, a person cannot just register anything for patent protection. They have to show that their invention is patentable subject matter and that it is actually a patentable invention. So let's talk about what that entails. Firstly, they have to show that what they want to register is the right kind of subject matter. Everything for patent subsistence or registrability rather, is set out in Section 18 of the Patents Act. And the Patents Act provides that there are certain things, right, that cannot be registered just as a matter of course. You cannot register naturally occurring things. You cannot register human genetic material. Basically, anything that is a discovery and not an invention. You can't just stumble across something and then get a monopoly right for it. You have to show under Section 18 that it is a manner of manufacture. Now, what does this mean? It was defined in the NRDC case to mean a vendable product or process. And in that case, the court set out sort of what is a vendable product or process. It means an artificially produced state of affairs. So again, right, it's not a discovery. It's something that has actually been invented. It must be useful. It must belong to the useful arts rather than the fine arts. It must have a practical application. It must have a trading, commercial, or industrial character. And it must provide a material advantage in the field of economic endeavor. So basically, it has to be practical, it has to be useful, it has to be commercial or capable of commercial exploitation. Nothing that is naturally occurring, general discoveries, theories, that sort of thing. All right. So if a person has a manner of manufacture, a patentable subject matter, they then must go through the rest of Section 18 to show that their invention is actually patentable, because there are rules about what you can and can't patent based mostly on whether the invention is actually new or not, right? So what the language of the Act is that the invention must be novel. It must be novel when compared to the prior art base as at the priority date. These are all terms of art within patent law. The priority date is the date at which the person is trying to register their patent, right? The date at which they are lodging their application to register their patent. And the prior art is basically the information that exists before that date. And what the patent examiner will look at is this invention actually new, actually novel, compared to what we knew as at that date? What has been disclosed already in public or in publicly available documents? So usually this will be in a research article or in a presentation at a public conference, that sort of thing. When we look at what we already knew, is this invention actually novel? And we know that We can ascertain that by applying what is known as the reverse infringement test. Basically, if the applicant had a patent over their invention, would the information, would this research article be infringing that patent? Would it be doing something that we would say is within the patent owner's exclusive rights to exploit their invention, which includes sort of making the invention, commercializing the invention, all of that sort of stuff. And if it would, then we say, okay, well, then the patent has been anticipated by this prior art. It's not new. It's not a new thing, and it's not capable of being registered for patent protection. The Act does provide a grace period for some disclosures, in general, disclosures by the inventor themselves. So if I have invented something, I'm a university researcher, I probably want to be talking about my invention in my research publications, at my conferences, with my academic peers. I can do that for 12 months before I register for my patent and not lose patent protection. But I only get 12 months to talk about it publicly, right? Because the more I talk about it publicly, then that becomes part of the prior art. Everybody knows this information. And then all of a sudden, I'm destroying the newness, the novelty of my own invention by talking about it too much. So I get 12 months grace period. And after that, I have to have it registered to have protection over it. The invention must not only be novel, but it must involve what is known as an inventive step. And this is defined as not being obvious to a person skilled in that relevant fields of technology, or they call it the relevant art. So if the kind of research I'm doing is, let's say I have invented a new mechanism for making, I don't know, chairs, right? Before we made chairs in a certain way, and now I have built a new machine to make them in a whole new way. It's novel, right? It hasn't already been done before or talked about before. The next question is my chair making machine inventive? And we do that by asking, would somebody else in this field, right, of manufacturing or furniture making, would this kind of development have been obvious to them or not? Because if my machine is just a sort of incremental step that everybody sort of would say, yeah, well, whatever, like that's the obvious next step, then it's not going to be inventive enough to get patent protection. So it must involve an inventive step, as in it's not obvious to somebody who works in that area. The invention must actually be useful in the sense that it must actually work as described. And it must not have been secretly used before the priority date, so before the registration date. So I already said that I can't go around talking about my invention or publishing on my invention for too long prior to when I want to register my patent. Well, the flip side of that is that I also can't be doing this. I can't be using my invention secretly first, right? Because that would involve me basically extending my monopoly beyond the 20 years. I can't secretly use my machine to make chairs for 10 years and then get a patent and have monopoly protection for another 20 years. No, I get again a 1-year grace period, and then I have to register for protection if I want a patent, right? Because the quid pro quo of patent protection is that I have to publicly disclose in my application. When I apply for a patent, I describe my invention and I have diagrams and everything, and I tell a person exactly how it works in my patent application. And if I am granted a patent, then that application becomes public, right? Because we're trying to advance science and advance inventions. So the information becomes public. I get a monopoly for 20 years, so I can stop people using that information and building my invention for 20 years. But after that point, my monopoly ends and anybody can make and use that invention, and they need to know how to do that. So that is why we publish those claims that I've made and my patent application. All right, so if I can satisfy all of those steps, then I have a patentable invention, I can register it and have patent protection. So let's just quickly go over that. I must have patentable subject matter, right? An invention, not a discovery. And it must be a manner of manufacture according to the NRDC case. I must, at the priority date, right, the date I'm filing my application, my invention must be novel, so it hasn't been publicly disclosed already. And it must involve an inventive step, so it must not be obvious to somebody working in the relevant field. My invention must be useful, as in it actually works, and I must not have been using it secretly before the priority date, subject to the 12-month grace period. And if all of those are satisfied, then you have a patentable invention. So getting a patent registration is the first half of patent. The second half is whether or not somebody has infringed on the patent once it is granted. Because a patent gives the patent owner the exclusive right to exploit the invention during the term, right? During that 20 years. And exploit means to use, to commercialize, to allow others to do those things, to make, right? It's quite a broad definition. And if somebody else does any of those things within that 20 years, I can bring an infringement action against them under Section 120 of the Patents Act. And what happens in an infringement claim is that the court will look at the claims that I have made in my patent application, right? I have to set out my invention does 1, 2, 3, 4, right? Exactly what it does. And they will look at what my invention does and what the allegedly infringing invention does. And they will say, has that taken all of the essential elements of my invention, right? All of the essential elements. And that the relevant case here is Catnick. It talks about whether the infringing invention takes what is the pith and marrow of the invention, which is basically, has it exploited it or copied it in substance, right? Even if these things are not all exactly done exactly as I set out, in substance, has it taken all the important parts of my invention? If it has, that is infringement. There are some exceptions set out in the Patents Act for being able to use an invention during the patent term. The most relevant one is experimental use. There are some uses that are allowed for basically testing the claims, doing experiments with the invention before the patent runs out for research purposes, and in particular, so that once the patent expires, competitors can hit the ground running in terms of making that invention and exploiting that invention. So it's useful to think about this in the sense of pharmaceuticals, right? When a patent expires, we get generic medicines on the market, and other pharmaceutical companies are able to run tests on the medicine that is under patent protection, even though they can't actually produce it, they can't actually sell it, etc. during the patent term, so that once the patent expires, they can start producing and selling the generics. And so then conclude, obviously, is there an infringement and what are the likely remedies? So pretty straightforward here. You use the patent owner's rights as to exploit the invention. Has there been an infringement of all the essential integers of the patented invention? Is there a defense? And therefore, is there or is there not an infringement? So that is just a super quick recap of patent law.